in case a debtor is finding it difficult to pay off his liability, he might file a bankruptcy petition with the court. Okay, so this could happen voluntarily by the debtor himself when he finds that it is difficult for him to pay. He's not able to pay his liabilities as and when it becomes due. Okay, so it could be either voluntarily or his creditors can push him into bankruptcy. So typically we are discussing bankruptcy chapter 7, okay? Chapter 7 bankruptcy, and we are talking about chapter 11, okay? And then chapter 13. Though we have many other chapters under bankruptcy codes, we are typically discussing these three, okay? Okay, so basically let's go to the notes and understand this further on, right? Chapter 7. So what are the specialities about chapter 7? Under chapter 7, liquidation. Okay, this is called a liquidation. Okay, chapter 7 is called a liquidation. Okay, a trustee is appointed. Trustee comes over and takes over the control of all the assets of the taxpayer, okay, or the debtor, okay, and then tries to satisfy the creditor's claims with the available assets. Okay, so this could be voluntary or involuntary. Okay, so the trustee is basically appointed to take control over the property to pay off as much as that can be satisfy uh, the the creditor's claims. Okay, so individuals as well as partnerships and corporations can file Chapter 7 liquidation. Okay, so usually railroads, insurance companies, banks, savings and loan, small business investment companies are not supposed to be filing Chapter 7. It's not available to them because it involves public's money, isn't it? So therefore, these people cannot voluntarily, apply for Chapter 7 liquidation. Trustee would take control of all the properties of the uh, debtor, and then there is a section 341 meeting held, okay, within 20 to 40 days of the application being filed for liquidation. Okay, and this in this meeting basically it's a creditors meeting. Okay, creditors will have a opportunity to file a proof of claim. Okay, and of course creditors, most of the creditors has to participate, and the court will approve uh, an relief. Okay, so if it is voluntarily, then there is an immediate stop for the collection efforts from all of the creditors. So that immediate stop allows the debtor to breathe a little bit, okay, to discuss things. Now for individuals, okay, uh, typically, if they cannot really get into Chapter 7 liquidation, they might apply for a Chapter 11. This is called, this is not a liquidation, this is a business reorganization. Okay, so which means that business will still continue, typically available for partnerships and corporations, but individuals who does not meet up the criteria for Chapter 7 can get into Chapter 11 or Chapter 13. Okay, so typically there's no trustee involved in this. Okay, it could be again voluntarily or involuntary. Brokers, stock brokers, insurance companies, banks, savings and small business investment companies cannot file Chapter 11 reorganization. And here the typical thing is the debtor remains control of the assets, and he still continues the business. Okay, the business is not on hold. Of course, we have a Section 341 creditors meeting where the creditors file a proof of claim. Okay, typically there's no trustee appointed, and the court will approve. Once the court approves the plan for the creditors, then uh, shareholders should apply and get the court to apply or approve on the plan. Okay, and the court might approve it if it finds that it's fair to approve this particular plan to the debtor. Okay, here debtor is getting a chance to basically reorganize his business and continue. Okay, under Chapter 13, this is called a debt adjustment plan, okay, whereby this is only applicable to individuals, as I said. Now, individuals who do not meet up the criteria with Chapter 7 can apply under Chapter 13 as well, okay. So here a trustee is appointed. Usually, a trustee comes in, and trustee and the debtor, they sit together and discuss the things and how to restructure the debts. So probably most of the companies would have or individuals do have a problem of liquidity, right? They might have assets, they might have other provisions, but they are not able to pay on time to settle off the liabilities as and when it comes due. Okay, so this is again voluntarily. Okay, um, okay, and so how do they restructure this? Probably they have certain, let's say, in case of an individual, they can work out the capital structure, right? Probably taking more owners if they have a business or something like that, which they file, Schedule C, or probably selling off certain assets and paying off their liabilities. So these are the options available under Section 13 or Chapter 13. Section 341 creditors meeting is held again. So in all cases, you're filing as a file of claim, proof of claim. Okay, but the creditors often do not participate in the meeting. Okay, and uh, debtor would need to submit a repayment plan uh, by the trustee appointed by the court. So if you see the differences, okay, if you, it's better that we relate that and study this together. Okay, under Chapter 7 liquidation, um, basically a trustee is appointed. Okay, a trustee is appointed under Chapter 7. Okay, and under Chapter 11 there's no trustee. Okay, under Chapter 13 there is a trustee. Chapter 7 could be voluntary or involuntary. Again, Chapter 11 could be voluntary or involuntary, and Chapter 13 is only voluntary. Okay, um, so this is applicable for individuals, partnerships, and corporations. Chapter 13 is only for partnerships or corporations, and Chapter 13 is only available for individuals. Okay, and in all cases, there is a Section 341 meeting being held. Okay, and court has to approve the plan. Okay, of the meeting. All right. So let's get into chapter 7 in detail. Now, if the debtor, it could be voluntarily and involuntary, right? So debtor files a petition for automatic order of relief. The court immediately orders the relief of automatic stay on all the collection efforts, and then once that happens, the usually the creditors you know have to file a claims before the claims bar date ends, which usually is 90 days after the 341 meeting. So they have to file a proof of their claim within 90 days after the 341 meetings are held. Okay, so an order of relief which may help the debtor to relax a bit. Okay, and then the creditors will have to get into the filing of their proof of claim. So who can now, if it is involuntary cases, okay, who can push the debtor into a chapter 7 or a chapter 7 or chapter 11? Okay, so the creditor has to be proving that the debtor is not paying debts when it is coming due. So it doesn't mean that the debtor is insolvent. The you know Only they have to prove that the debtor is not really paying. Okay, and who has to file a petition now if it is an involuntary case? Somebody who owes at least or owns at least 16,750. Now this figure could change as year by year, so you're advised to check on this figure whenever, if you're reading it or if you're watching this on a different time. Okay, so you got to be checking this amount. It always is adjusted for inflations. Okay, so only creditors who are owed individually or in aggregate of at least 16,750, okay, in unsecured, undisputed debt may file a petition. So, secure creditors are not supposed to be filing because their claims are secured by collateral. So, unsecured creditors are the ones who are filing these claims. Now, let's say if the debtor has fewer than 12 creditors, okay, at least one who has owed 16,750 can file. Okay, fewer than 12 creditors, at least one, okay, or more, who is owed 16,750 has to file a claim. Okay, now let's say if the debtor has 12 or more creditors, 3 owed 750, 16,750 can file. If the debtor has 12 or more creditors, at least 3 creditors who are owed at least 16,750 in aggregate, unsecured, undisputed debt, must join the voluntary petition. So you need to make sure that, okay, there are at least 3 people to join the petition if the creditors have 12 or more creditors. The debtor gets an If the debtor doesn't object, okay, he gets an immediate order of relief, okay, which is usually 20 days. So once the debtor gets an order of relief, then all the collection efforts has to stop. So here the creditor files a proof, okay, or the creditor pushes the debtor into bankruptcy. Okay, the court approves an immediate order of relief, usually within 20 days. So there could be some suppliers who are supplying the creditors during this period, okay, after the filing, but before the order of relief. These are called gap period. So if any of the creditors have supplied to the creditor during this gap period, they have a priority on distribution of the bankruptcy estates. Okay, we'll see that later. So once the order of relief has been filed, then the creditors have to file a proof of claim within the claims bar date, usually within 90 days after the Section 341 meet. Okay. Now, what are the initial bankruptcy proceedings? Um, in Chapter 7, filing a bankruptcy petition, debtor has to file certain documents, and then creditors 341 meeting has to happen within 40 days, 20 to 40 days. A claim of proof has to be filed within the claims bar date. A trustee is being appointed, okay, and a trustee takes the control. Court provides an order of relief. This is an automatic for voluntary petition and needs to be approved in case of involuntary petition, because when an involuntary petition happens, oftentimes the debtor can object to it. Okay, debtor can prove that he's paying the dues as and when it becomes due. Therefore, he's not. He shouldn't be, pushing. Uh, he shouldn't be pushed into bankruptcy. Of course, once it is approved, the debtor has to file a list of all the creditors and their addresses, a schedule of the assets and liabilities at fair market value, which is available to the debtor, a schedule of current income and expenditures, also an increase in that. Okay, if you're expecting expected increase, if you are expecting an increase in your income, that needs to also to be noted. A statement of financial affairs, okay, copies of payroll stubs, okay, within 60 days, because that can come in to the estate. Okay, so basically, let's say you're receiving a certain payment from your employer, okay, even post uh, uh, bankruptcy petition, that can be included in his estate. Itemized statement of monthly income, okay, or anticipated increase in income, as I said, or expenses, copy of federal tax returns filed during the last year, okay, list of educational IRAs and qualified tuition programs. Oftentimes, these are excluded from the estate, and that's the reason they want it to be filed. You also, before you can get into a bankruptcy under Chapter 7, you need to get a certificate from a credit counseling agency. You need to get a briefing from the credit counseling agency on how to manage your funds, right? So the briefing must be within 180 days of filing a bankruptcy petition. Okay, so if there is no briefing done, you don't get exempted for your debts under Chapter 7. So a credit counseling agency's briefing has to be undergone. There needs to be a certificate, valid certificate. Okay, and as we said, Section 341 creditors meeting has to be there. It usually happens from 20 to 40 days after the order of reliefs. Okay, so the creditors meeting has to be attended by all the interested creditors who have a claim. They have to file a claim. Also, the trustee has to be present. The debtor must be given a notice of the meeting. All the creditors must be given a notice, and all of them meet together. It gives an opportunity for the creditors to see the claims of the debtor. Okay, and then a proof of claim has to be filed by the creditors by the claims bar date. Okay, it usually is 90 days after filing the petition. Okay, 60 to 90 days. This is what they say. Okay, so all of these creditors will have to file a proof of claim. Now, let's say if it is a corporation that's going into a bankruptcy, then all the shareholders will have to file a proof of interest. Okay, a trustee is either elected by the court, or in the 341 section 341 meeting, creditors might appoint a new trustee. Okay, trustee, of course, he is given a compensation for his services rendered. He gets a priority. So, of course, lots of professionals are working in a bankruptcy issue. Tax preparers, accountants, lawyers, CPAs, all of them together work together. The duties of trustee is to collect, liquidate, and distribute the estate, and keep accurate records for all the transactions, and liquidate the assets, available assets, to basically to the best way as possible to settle the claims of all the creditors. So trustee has a lots of responsibilities and duties, collecting the property of the estate, challenging certain transfers in property, using, selling, or leasing the property, disposing or investing money in the estate, employing attorneys, accountants, appraisers, actuaries. Okay, um, so these are the powers that a trustee in a bankruptcy has. Now, trustee also has certain avoiding powers. Okay, if the trustee sees that these transfers uh, were done by the debtor at the cost of all the other creditors. Okay, otherwise these transfers would have been helping the other creditors. So trustee has certain authorities to avoid certain transactions that has been done by the debtor. So trustee has to make sure that he or she maximizes the property included in the bankruptcy. Okay, so it has to make sure that maximum assets are included in the estate in order to pay as much as to the creditors. Okay, so it can set aside or avoid or cancel certain transactions that has been executed by the debtor. So any of the fraudulent transfers which were done by debtor even before 2 years of filing a bankruptcy petition could be avoided by the trustee. Okay, so any fraudulent way, if the if the debtor knew that he was getting into a bankruptcy, in order to avoid his creditors getting into, gaining the access to the property, if he has fraudulently transferred these assets to another party, trustee has a power to take it back. Okay, or after filing the petition, if the debtor has transferred certain assets, okay, this could be avoided by the trustee because basically this should have been supposed to be a part of the estate, okay, available to pay off the other creditors' claims. Okay, there are certain statutory liens which are available. For example, artisans liens, mechanics liens that we call it, right? Usually these are statutory liens, but trustee has basically powers to avoid them. Okay, for example, mechanics liens work like this. Let's say the debtor has a TV and it is given for repair, right? And debtor is unable to pay for the repairs. The repairman has a statutory lien of mechanics liens to hold the TV, okay, for settlement of his repair charges. But of course, the trustee has a power to avoid that. Okay, any other preferential transfers that the debtor has done, okay, within 90 days before filing the petition, okay, preferential transfers, okay, um, or if it is like uh, insiders, okay, any preferential transfers done to an insider, okay, who is a related party, who is a friend, who is a buddy of the debtor, okay, even within 1 year, the trustee can take it back, cancel the transactions and take it back. So debtor is not allowed to, anticipate that he's getting into the bankruptcy. So therefore, in order to avoid, these assets getting into the bankruptcy estate, debtor might do also all sorts of things. So the trustee has avoiding powers for all of these instances. Okay, it's okay as long as the debtor was paying for usual antecedent debts, okay, or he was paying rents, which is otherwise also to be paid, right? So therefore, these are not considered as preferential transfers. So preferential transfers includes all transfers that were at the discretion of the debtor, okay, in order to escape them getting into the bankruptcy state. Usually, the trustee avoids all payments to charities, uh, all payments which are done for ordinary business, okay, and usually alimony and child support, okay, and any payments on perfected security debts, because otherwise also it doesn't become a part of the estate, because these PMSI creditors does obviously have a priority before the trustee itself. So therefore, these transfers the trustee will not touch. Okay. So now, what is the order of priority? Now, the trustee sees that, trustee avoids all these transactions and everything. Trustee basically makes sure that, the bankruptcy estate value is maximized. So in order to pay off all the creditors, right, as much as possible. Okay. So usually the assets of the debtors, okay, are sold by the trustee, and it's first paid to all the secured creditors, fully secured creditors, because of course they have a claim, right? Fully secured creditors, it first goes to the fully secured creditors, then it goes to the partially secured creditors. So who is a partially secured creditor? Let's say somebody has a claim for 100,000, but he only have a 50,000 collateral for that. So these are called partially secured creditors. So after the fully secured creditors have been paid, partially secured creditors gets paid. Okay, and then it goes to the priority claimants. Okay, which we'll see in a while, who all are these priority claimants. So, first priority claimant is the payment for alimony and child support. Okay. And then it goes to the administrative expenses for the trustees' fees, attorney's fees, and accountant fees. So this is the priority number one, child support and alimony payments. And second is administrative fees to the trustee and attorneys and accountants. Third is for the gap creditors, involuntary gap creditors, people who have basically supplied the debtor after the order of relief, before or before the order of relief, and after of filing a petition. So basically they have helped the debtor to survive. So these people are called gap creditors, and they have a priority. Their priority is three. Then it goes to the employee payroll, okay, and pensions. Okay, per employee, these are the new amounts, 15,150. Okay, per employee during the last 180 days. Okay, they have a claim. So anything more than that, it'll go to, if the bankruptcy estate has further money, they'll get the additional amounts if they owe more. So up to 15,150 claims during the last 180 days. Okay, employees gets the fourth priority. And farmers and fishermen, any payments to them, okay, up to 7475, they get they get a fifth priority. And if any of the individuals, consumers, okay, they have deposited money with the debtor for any of the items to be delivered to them, and if the debtor has taken money but not delivered the items, so they are called consumer deposits up to 3350. They have priority number um, 6. Okay, so basically, it works like this: employee payroll will have fourth priority, employee pension will have fifth priority, uh, producers of farmers and fishermen, sixth priority, individual consumer deposits have seventh priority, and tax claims obviously they have eighth priority. Okay, not seventh here, but eighth priority. So basically, any of the tax claims arising from last 3 years from the petition, okay, IRS have a priority. And the ninth priority is for any claims that of the drunk driver injury claims. Let's say the debtor, basically committed an accident and somebody was injured by means of that accident. Okay, any claims of such cases, the debtor was drunk and basically he created injury to somebody. Okay, this claim has the ninth priority. So if you see, what are the priorities again? First priority goes to child support and alimony payments. Second is trustees fees, accountants fees, all the administrative expenses. Third priority is for gap period creditors. Fourth is for employee payrolls up to 15,150. And fifth is employee benefit plans. pension plans. Excuse me. And sixth is producers and fishermen up to 7475. Seventh is consumer deposits, okay, for items not delivered up to 3,350. And tax claims are the eighth priority, and drunk driver claims, injury claims, uh, the ninth priority. So these are the ways that the assets of the unsecured creditor debtor is paid to the unsecured creditors who have filed a proof of claims. So if the proof of claim is not really filed, okay, uh, their debts, their claims doesn't get discharged in a bankruptcy. Okay, all other claims are paid an equal percentage of amount owed. Okay, who have lower claims. Um, okay, and if there's nothing left, okay, they don't get anything. Okay, sometimes Chapter 7 can get discharged. Okay, so a denial can happen. Okay, so what is a discharge of debt? Okay, most of the debtors' debts are discharged under Chapter 7. Okay, he is not answerable for those debts. Okay, of course, debtor can reaffirm a certain discharge debt. The debtor can say that, I don't want this debt to be discharged. I will pay for it. Okay, so he can reaffirm a particular debt if he wants to really pay that, maybe for any reasonable feelings that he has for that kind of debt. But of course, he should be advised that once he reforms this, and then this would not be discharged, and he has to take, of course, the responsibility for that debt. Okay, and courts usually inform these consequences of reaffirming a particular debt. Okay, so most of the debts get discharged under the Chapter 7. Okay, what are the exceptions? Certain debts may not get discharged. These are loans obtained by the debtor by fraud and false representations. These are not dischargeable. Okay, fines and penalties often not dischargeable. Alimony payments, child support, okay, these are not dischargeable. Now, if you see, these had a priority also, and it doesn't get discharged as well. Okay, and student loans, tax claims from the last 3 years of petition. So, if not all of that is not paid, it still haunts him. So now these things are exceptions. So these are never discharged. Credit card payments, if the debtor has purchased luxury goods of 725 or above within 90 days of filing, okay, it doesn't get discharged. Auto loans within 3 years of filing, cash advances of up to 1,000 within 70 days of filing, these are not get discharged. Any unscheduled, unlisted debt, if the debtor fails to list a particular debt, that doesn't get discharged. And drunk driver insurance claims or death judgments, that doesn't get discharged. So we understand that most of the debts get discharged, okay, and some of these, okay, will never get discharged. It still will haunt him, okay. Um, so if he has used any fraud and false means or representation to get a loan, fines and penalties, alimony supports, student loans, tax claims, credit cards, using credit cards for buying luxury goods, okay, or cash advances from credit cards, unscheduled, unlisted dates, okay, drunk driver injuries, all these will not get discharged. So sometimes debtor can get a denial, okay, and once the debtor gets a denial, he again owes to everyone else. All the creditors are basically at the same point now. So how does it happen? If the debtor does not keep proper books and records, or doesn't want to accept, you know, um, the bankruptcy court's proceedings, or refuse to explain why there is certain assets, missing. Maybe he's transferred something. Uh, Bankruptcy offenses, withholding records, refusing to obey the court law, okay, or he has already been, discharged in a bankruptcy, Chapter 7, within 8 years. You can't do this every often, right? You have to wait 8 years before filing another bankruptcy. So if it is your regular business of filing, taking loans, using it, enjoying it, and then filing bankruptcy, that doesn't work. A particular 8 years must elapse before you can get discharged. Okay, so all of these cases, uh, debtor can get a get a denial for his application if he's filing voluntarily. So that's about bankruptcy, guys. Good